Hi guys, hope you're all doing good. Welcome to another session of News in 30 Minutes. Today, let us discuss the important issues on 2nd of November 2023. Before that, let me just remind you that on reaching 2000 subscribers, a very interesting series is waiting for you people. That is the TNT series. So I hope you get your friends, your peers to subscribe to the channel as soon as possible, so that we can actually make use of this TNT series that I have worked hard and I've already got it ready. So we are just waiting for reaching the milestone of 2000 subscribers so that it gets unlocked as soon as we get there. Okay, so with that, let us start off with today's important issues. The first issue is a very important issue. There are very high chances for this to again come up in prelims as well as mains. The article says that AI and the issue of human centricity in copyright law. Okay, so basically this article is talking about AI and its complications within intellectual property rights. Okay, so which is known as IPR. Okay, with the coming of artificial intelligence, it has created a lot of complications within the intellectual property rights. So this article talks about one such complication called copyright law. Okay, now before I get into the article, just let me give you a glimpse of what exactly is intellectual property rights. Basically, intellectual property right is an intangible creation of the human mind. Okay, it is an intangible creation of the human mind. See, it is intangible. Okay, hence protection becomes very important if we have to facilitate such intellectual properties. Okay, so protection is given through IPR laws. Okay, the intellectual property right laws gives protection for these intangible creations of human mind. That is first. The next is, in India, if we take intellectual property rights, there are 7 types of intellectual property rights in India. Okay, the first is copyright. Okay, the second is trademark. The third is patents. The fourth is geographical indicators. The fifth is plant varieties. Yes, even plant varieties are protected. The sixth is industrial design. And the last is semiconductor integrated circuit designs. Okay, so in India, these are the 7 intellectual property rights that are protected. Okay, again very important from prelims as well as mains perspective, so get to know the basics always. Intellectual property rights are intangible creations of human mind which requires protection that is done through IPR laws, and there are 7 types of IPR, that is copyright, trademark, patents, geographical indications, plant varieties, industrial designs, and semiconductor and integrated circuit designs. Okay, I will get into the depth of each and every one, but before I get into the depth of each and every one, let me just give you a glimpse of what this article is talking about. Okay, because it gives 2 very good case studies and it says how AI creates complications within IPR. Okay, so the first case study is the case study of USA. Okay, one is the case study of India, and the issue is happening is with respect to copyrights. Okay, and to give you a glimpse, copyrights in India is basically handled by Copyrights Act 1957. Okay, now see what the case study says is, in USA, a person called Mr. Thaler will file for a copyright on a visual art, and the author of this visual art, according to Mr. Thaler. The author of this visual art is Creativity Machine. The author is Creativity Machine. Okay, this Creativity Machine is an AI system. It's an AI system. So when Mr. Thaler filed a copyright on a particular visual art that was created by Creativity Machine, and this Creativity Machine was termed as the author in that filed copyright, this particular copyright was rejected. It was rejected, and the reasons given was human creativity. Okay, human creativity plus human authorization, or see, human authorization is important, okay, to grant copyrights. This was the statement that was told by the Copyright Office. It was told that to grant any type of copyright protection, the work, the creation had to have some type of human creativity and human authorization. Hence, the copyright was rejected. Okay. Now, let us come back to the case study of India. Here, there was a copyright that was filed on a work called Suryast. There was a work called Suryast, and on this the copyright was filed, and this Suryast was co-authored by an AI painting system. It was co-authored by an AI painting system called Raghav. It is co-authored by an AI painting system called Raghav, and when this was filed in the Copyright Office, this particular work was approved and registered by the Copyright Office. Okay. Now, this was registered though it was co-authored by the AI system. Now, look at this. There is complete dichotomy in the way the copyrights are handled in USA as well as in India. Now, why do you think this case study is important? Is because the Parliamentary Standing Committee, okay, the Parliamentary Standing Committee has recommended, that the Copyrights Act 1957 as well as the Patents Act 1970, okay, these needs to be looked at from the angles of artificial intelligence. This is the recommendation given by Parliamentary Standing Committee. Okay, so this recommendations is not yet followed, and hence you can see what is the outcome. Okay, though a particular work is co-authored by an AI, that particular copyright is being approved, this creates a complication. The complication is what type of creation and what is the level of human intervention is required for you to approve a copyright, a patent or a trademark. That questions will arise due to the coming of artificial intelligence into the realm of intellectual property rights. Okay, so what is this regulation? We have to wait and see. However, we are looking at dichotomy in the realm of intellectual property rights because of the coming of artificial intelligence. Okay, so I hope you got the case study. Now you need not always wait to use this case study if they ask you intellectual property rights. You can ask, or you can use this in your essay, how technology needs to be regulated. You can use this in your ethics. Okay, how decision making will become complicated. So there is wide array of opportunities for you to use such case studies. You need not always wait for them to ask you the case studies, as I keep telling you again and again. Okay, that is one. Now the next is, the moment you are reading this particular article, okay, you understood that there is something called copyright law, and you understood that copyright is something called intellectual property rights. So from current affairs, you have to go back to the basics. So I went back to the basics and I told you what is intellectual property rights. And I also told you that there are 7 types of intellectual property rights. Okay. And I told you these are intangible creations and hence they require protection in the form of laws. If that is the case, the next thing that you should know is you have to study these laws. Okay. So if there are 7 types of intellectual property rights, then there has to be 7 types or 7 laws that regulate or protect this type of intellectual property. Okay. So the first law that protects intellectual property is Copyrights Act 1957. The second is Patent Act 1970. The third is Designs Act 2004. The fourth is Geographical Indications of Goods Act 1999. The fifth is the Protection of Plant Varieties and Farmers' Rights Act 2001. And the seventh and the last is the Semiconductor Integrated Circuit Layout Design Act 2000. This is the Semiconductor Act. Okay. So if you can observe, there were 7 types and there are 7 laws. Okay. Now see, when I am going through this Copyrights Act, now I will give you an example of how I will only take things that I require for the exams, not anything more, anything less. Usually what happens is when you are going through these laws in the internet, you tend to copy more English, okay, and less content. Okay, that is why you will end up creating a very bulky notes. What is important is if you know what is required for the exam, then you will take only the things that are required for the exam. Okay, so let me give you an example or a glimpse of how to elaborate or extract the content from these laws that are only important from prelims perspective. Okay, let us see how to do this. So if I take Copyrights Act 1957, one thing is what are the things where copyrights are granted. You should have an idea of that. So for that, copyrights are usually granted for creations of literary, drama, as well as music. Okay, it is mainly given to this 3. The next is the protection is given up to 60 years. Okay, now the next is the owners will have the right to claim ownership, as well as the right to claim for damages. Okay, see, they have the right to claim for ownership as well as they have the right to claim for damages. Okay, the next is India is a signatory of Berne Convention. Berne Convention talks about international copyright protection. Okay, so because India is a signatory of Berne Convention, if a copyright is approved in India, then all the signatories of Berne Convention must follow or abide by this protection given by Indian laws. Okay, vice versa will also happen. If any member countries in the Berne nation approve a copyright, then that copyright approval must be respected by India because India is also a signatory of Berne Convention. So basically Berne Convention is an international copyright protection law. Okay, so this is these are the facts that is important for me from prelims perspective. Are you seeing this? So basically I took 1, 2, 3 and 4. See, 4 points is all I took after reading the entire provisions of Copyrights Act 1957 because these 4 I felt is what is important from prelims perspective. So whenever you read something, you should only extract those things that are necessary for prelims. Now, whenever you read the same thing, if you feel that they are important from mains perspective, it is completely different. Okay. Now let us come to the next act, that is Patents Act 1970. Okay. In the Patents Act 1970, what is important is 1, it protects the investors or it protects the rights of inventor. It protects the rights of inventor from any new invention. So this new invention done by the inventor will be protected. Now the grant of protection will be for up to 20 years. Okay. And the next is what is important is the invention must suffice the condition of novel as well as original. What happens usually many a times is these many inventors, they just reverse engineer the process and they just change the process, but the end product will be the same. Okay, so just by changing the process and keeping the end product same, they will try to claim the patent. So the important thing is any new invention should always be novel as well as original. The second is because they have to create the process. Because there are very high chances of reverse engineering the process, they say that we have to employ something called inventive steps in the process. Otherwise, it will not be considered. Okay. So to summarize, the Patents Act 1970 gives rights of inventor or protects rights of inventor for any new invention, provided that the invention will solve or the invention should be novel as well as original. And the process through which that new invention is done will have inventive steps. What is inventive steps? Inventive steps means it has to involve a technical advancement It has to have a technical advancement. It cannot be based on existing knowledge. This is what is inventive step. So it has to be based on some technical advancement and it cannot be based on existing knowledge. Okay. So this is what is inventive step. Inventive step has to be in the process. The product that is invented should be novel and original. Only then the rights of inventor for the new invention is protected under Patents Act. For how many years? For 20 years. This is what is Patents Act 1970. Okay. The next is Designs Act 2004. This is basically for industrial designs. There is a very elaborative definition of what can be considered as a design. Okay. And the Designs Act, okay, this basically the Designs Act, once it is approved, a design is approved, it can be given protection for up to 10 years and this can be extendable. After 10 years, it can be extendable for a further 5 years. You're seeing this. So Designs Act basically is for industrial designs. The definition of what is a design is very elaborative in this act and the protection given to the design is 10 years that can be extendable for another 5 years. So I hope you got the prelims perspective importance of what is Copyrights Act 1957, what is Patents Act 1970, what is Designs Act 2004. Okay, let's go to the next one. Now, just give me a minute. All right, I have missed out on one. 4, 5. Let me just write down one here. One is Trademarks Act 1999. Okay, I missed out on that. So let me just tell you what Trademarks Act 1999 is. This basically is a protection given for graphical representation. Okay, that graphical representation can be symbols, it can be shapes, it can be words. Okay, these are all trademarks. Okay, basically what is important is this representation must help in distinguishing. It must help in distinguishing goods or services of one from another. That is the end purpose of Trademarks Act. Okay, one, it is given for graphical representation. Example, symbols, shapes and words. It distinguishes, the main purpose is distinguishing the goods and services between two entities. Okay. Now, what is the validity? The validity is 10 years. The protection is given for 10 years. Okay. Now, after that, it can be renewed perpetually. It can be renewed perpetually for successive 10 years. So you can keep renewing it for every 10 years perpetually. So that is how trademarks work. It works for every 10 years and then you have to renew after the 10 years and this can keep being done perpetually. Okay. The next is Madrid Protocol. Okay, Madrid Protocol. India is a signatory of Madrid Protocol. It is again international protection of trademarks. Okay. So if a country that is signatory of Madrid Protocol approves a trademark, then it is a necessity for other members of the Madrid Protocol or the signatory of the Madrid Protocol to abide by that approval and make sure that they respect that particular trademark. So that is what is Madrid Protocol. So Madrid Protocol has to do with trademarks. See, prelims perspective of what is trademarks is done. Okay. So the next is, we are done with 4. The next is Geographical Indicators of Goods, Registration and Protection Act 1999. Okay. Now, what is this Geographical Indications of Goods Act 1999? It is nothing but, see, these goods can be agri goods, they can be natural goods, or they can be manufactured goods. See, they can be all the 3 types: agri, natural as well as manufacturing. Okay. Now, these goods, one, they can involve production, they can involve processing, or they can involve preparation. See, either one, it need not be always all the things, either one happens in a locality or a region. Okay, either one happens in a locality of the region and the reputation of that product is because of that region. I hope you understood. The reputation of the product comes because of that region. Then you have to give the geographical indications for that particular product. So let me repeat, the GI tag. Okay, the GI tag can be given to agri goods, to natural goods and to manufactured goods wherever the production or processing or preparation, either one, is done in a locality and that product's reputation is coming because of it being prepared or processed or produced in that particular locality, then GI tags are awarded. Example, you can take Muga silk. Okay, Muga silk is a GI tag that is given to Assam because the production of Muga silk happens in Assam and the reputation of that silk comes because of that production in Assam and it comes under agri goods. Okay, Darjeeling tea, okay, comes under agri goods. Okay, Kanchipuram silks comes under manufactured goods. I hope you are getting the idea. Okay, so this is what is GI tag. Okay, again it is awarded for 10 years and after 10 years you can further renew it for the next 10 years. Okay, so overall the net is 20 years, 10 years and after that you can renew it for another 10 years. Okay, so this is what is GI Act 1999. The next is the Protection of Plant Varieties and Farmers' Rights Act. Okay, now the validity of registration or the validity of protection under this is 9 years. Okay, the validity of protection is 9 years for trees and vines and it is 6 years for crops. Okay, so this is about the validity of the protection of plant varieties. Okay, and the next is renewable the protection can be renewed. Okay, it can be renewed. The next is, see, in 1994 India signed something called trade related intellectual property rights. Okay, so it signs something called TRIPS. Okay, now according to which it becomes a necessity for all the nations which are signatory of TRIPS to protect plant varieties. Okay, it becomes necessary for all the nations that have signed TRIPS to protect their plant varieties, and because of this India created something called National Register for Plant Varieties. Okay, it's just a database of all the varieties of plants that are validated and that are protected under the Indian laws. Okay, so this is what is the Protection of Plant Varieties and Farmers' Rights Act 2001. Okay, this particular act has done tremendously well in protecting the farmers' right. As you can remember, there was a court case that was filed by Pepsi, against the farmers of Gujarat. And it was only because of the protection of the Plant Varieties and Farmers' Rights Act that the farmers' right was protected and the rights of farmers were upheld even in the judiciary. Okay, so this right has done tremendously well in the welfare of the farmers and protecting the rights of the farmers, especially on the endemic varieties and innovative varieties of seeds. Okay, and how they grow their plant. Okay, so this is what is the protection of plant varieties. The last one is the Semiconductor Integrated Circuit Layout Design Act. As you know, this is basically to approve circuits. Okay, semiconductor circuits. Obviously, the conditions of how and what all needs to be done to qualify for that circuit to be approved is given, which is not important from your exam perspective. The only thing is the protection given under this is also for the period of 10 years. Okay, so I hope you understood. These are the 7 important IPR types which are protected by their own IPR laws. Okay, so this is how you need to, once you see the current affairs, how to backtrack it and how to link it to the static is done through this particular article. So I hope you learned how exactly you have to backtrack a particular issue and go back to the static and study the static. Now, not only have you studied what is intellectual property right, you have also studied what are the types of intellectual property right, and you also know the laws that govern the intellectual property rights. Okay, so this is how you need to do the current affairs. So I hope the issue was helpful, and I hope you got an idea of what intellectual property right is and how it is regulated in India. Okay, so let's go to the next issue of today. Now, this is an unfortunate event that is given by the Ministry of Road Transport. Okay, and this particular ministry has said that in 2022 the total accidents was 4.6 lakh, and out of this 1.68 lakh were fatalities, unfortunately. Okay, this is 4.6 lakhs accidents in 2022, and out of which 1.68 is fatalities. Almost, if you see, 20% of the road accidents are resulting in fatalities. See, this fact again is very important for us to improve our technology within the vehicles, as well as improve our emergency services, so that accident prone regions are catered to as soon as possible. So again, these stats are not important for you to wait until they ask for road accidents. You can use these stats in different array of topics in a way where it is more innovative and giving suggestions. All right, so total accidents in 2022 was 4.6 lakhs, out of which 1.68 is resulting in casualties. Compared to 2021, we are seeing the accidents rose by 11.9%. So there has been a rise of 11.9% in accidents, and in deaths there has been a rise of 9% in deaths. So if compared to 2001, we are actually worsening in conditions compared to 2022. Then where is the technology, and where is the progress, and where is the modernization that is helping reduce the accidents and reduce fatalities? All right, this is all questionable. Okay, the next is one thing what we observed in this report that is given by the Ministry of Road Transport is national and state highways. National and state highways, okay, they account for only 4.9% of the total road network. Okay, they account for only 4.9% of the road network. However, though they account for only 4.9% of the road network, they are resulting in 56% of all accidents, as well as 61% of all road accident fatalities. Look at this. So what does it show? It shows that where is the focus area that we have to improve? The focus area is national and state highways. Though they constitute only 49%, this is where most of the accidents are happening. And the report also points out that the most common reason for the accident is speeding. Okay, so it says 72% of accidents and 71% of death is because of speeding. Look, that means there is a very high human error that is present. It lacks a common civic sense. It lacks a common road sense amongst the people of our nations, unfortunately. That is why you are seeing 72% and 71% happening because of speeding, which is purely a controllable aspect in accidents. Correct? So what can be done from law perspective, what can be done from technology perspective, if these are the two aspects. One more important perspective that we can add is what can be done from emotional intelligence perspective. Because what is more important here is looking at this fact. The importance is how to bring the behavioral change in the people of India. How to make them understand that this can be controlled and we are unnecessarily losing our lives on entities that are controllable with human emotions. Okay, so this is again, see how I can link the exact behavior into ethics paper. Okay, so the facts usually have no type of attachment to a particular section in the topic. You can use the facts in any way you want to attach it to any paper you want. That is the maturity and that is the proficiency that you develop in your mains exam by knowing facts in and out. Okay, so however, this is about this article. Okay, the next is a very short keyword that is used today. That is, EAT engine. Bangalore scientist overcame 200-year-old problem of Carnot engine. Okay, so in 1854, French engineer Nicolas Leonard Sadi Carnot, known as the father of thermodynamics, proposed what is known as Carnot engine, the most efficient engine which is theoretically possible. It is part of this theory on heat engine. So let me just tell you what. See, they may ask you recently in news, what is Carnot limit related to? Okay, so they can ask you in your prelims just like recently in news, this was the term used. What is this term? They can give you 4 statements and they can ask you different things. One, it is to do with heat engines, it is to do with biotechnology, it is to do with different like this, agriculture, it is to do with space. Like that, when they give you 4, when you don't, or when you have not heard this particular keyword, it will always seem like it is closer to space. Correct? So basically this is how UPSC plays. So whenever keywords, whenever there are keywords within the articles, always make sure that you understand a basic level of what that keyword is. Okay, see, Carnot Limit basically talks about power and efficiency trade-off. It basically talks about power and efficiency trade-off. So it says that when you want to increase the power, efficiency will decrease. When you want to decrease the power, efficiency will increase. I'll give you an example of motorbikes. Okay, if you buy a very powerful motorbike, the fuel efficiency will be very low. If you buy a motorbike that has very high mileage, that is fuel efficiency, okay, the power will be very low. Are you seeing this? So there is always a trade-off between power and efficiency, and that is what is Carnot limit. Now Carnot limit is a limit that estimates the maximum, it is a limit that estimates the maximum possible efficiency of a heat engine. Okay, so this maximum possible efficiency is what is the cap. This is what is the limit, the Carnot limit. Okay, if you take a heat engine, the efficiency of that heat engine will always have a limit, and what is the maximum limit of that heat engine is defined by Carnot's heat engine or Carnot's limit. Okay, so basically this scientist has found out some micro engine. This is basically at a microscopic level, and this microscopic level engine says that it is 100% efficient. Okay, which according to the second law of thermodynamics cannot happen, but this is what has been found out. Okay, now this is what is Carnot limit. So I hope you understood the keyword of Carnot limit. Okay, the last article is from 38 hours to just 12 hours, how new India-Bangladesh rail link can be a game changer for Northeast. Now, why such articles are important is last time they had given them as the following, when they had asked BCIM corridor constitutes which regions. They had also asked about trilateral highway. Trilateral highway between India, Thailand and Myanmar goes from which part to which part. Like this, they had asked 2 statements. So the point I am trying to make is whenever there are connectivity projects, in news, it is always important for you to know the places it connects. It is not just knowing the name of the connectivity, because everyone will know trilateral highway, but where they will overlook is from which place to which place is that connection happening. Okay, so hence I had added this article so that it becomes indicative of you how to choose the article. So this is a very important 15-kilometer rail link. As you can see in the image, it's a 15-kilometer rail link. It links Akhaura in Bangladesh with Agartala in Tripura. Okay, so before, if I had to travel from Kolkata to Agartala, I had to go to Siliguri, and from Siliguri I had to go to Tripura. So this entire journey constituted 38 hours. Now, since I can go directly from Akhaura to Agartala, it always reduces it to 12 hours. So this becomes very vital for Northeast development. Why it becomes vital for Northeast development is it helps in one, connectivity, and with connectivity comes accessibility. Okay, and with connectivity and accessibility, development becomes very easy. Okay, hence this project is very important. Okay, also it does good with our relationship with Bangladesh as well. Okay, with whom we share the longest border. Okay, anyways, so this is about today's important issues. I hope you liked it, and I hope you are getting a perspective of how to use current affairs in your prelims or well as mains exam. Okay, so if you have liked this issues, please make sure that you like, share and subscribe the video, and please tell your friends as well as peers to join the channel so that TNT series is waiting for you and that it can be unlocked. I'll see you tomorrow, guys. Thank you so much for tuning in, and thank you so much for all the support and all the love. Bye.